The term human rights is used to refer to the rights inherent to all human beings, regardless of race, sex, nationality, ethnicity, language, religion, or any other status. Everyone is entitled to these rights without discrimination. There are a few main legal sources of human rights, which include universal sources, European sources, and domestic sources. For employment purposes, human rights can be broken up into specific human rights and non-specific human rights. Specific human rights for employment purposes include freedom of association, which is the right to form and join trade unions for the protection of your own interests, the right to strike, the right to work, and the right to collective bargaining. Non-specific human rights for employment include the right to equal treatment and non-discrimination, the right of freedom of thought and belief, the right of privacy, the right of freedom of speech, and the right to effective legal protections. Although employees don't lose their human rights when entering the workplace, there is a conflict of interest between the employee and the employer. Human rights may be lawfully interfered on account of the duties arising from the employment relationship. Protecting the rights of others may justify certain limitations on someone's human rights. For human rights in the workplace, the proportionality test is used to determine if the limitation of human rights is justified or not. Note, this does not include discrimination, which has its own test. For the limitation of someone's human rights to be justified, the restrictive measure must first have a legitimate objective, secondly, be adequate to achieve the goal, thirdly, be necessary to protect the goal, and lastly, the protection of this goal must be more valuable than the restriction. Discrimination occurs when the principle of equality is interfered with. The principle of equality states that different treatment is tolerated only if it results from objective and reasonable grounds, and that the law must be applied equally for situations which are deemed equal. In the workplace, for employees or job applicants to be protected by the anti-discrimination legislation, the action needs to be in relation to access to employment, promotion, vocation, employment and working conditions, pensions, or termination of employment. If the action occurs within the scope of discrimination, it is then decided to either be direct discrimination or indirect discrimination. Direct discrimination is where one person is treated less favourably than another in a comparable situation. In this situation, there is very little to no defence for the offender. Indirect discrimination is where a neutral provision puts a person at a particular disadvantage compared to another. It allows for a defence by the defender if the provision can be justified by objective reasons. Having decided which category of discrimination the action falls into, each type of discrimination will then have its own test to determine if discrimination has occurred and if it is justified. Thanks for watching.